Please rise. Au hea o ko e oka aha nahe kuiana iwa o kea aha o kolo kolo ki ke hano hano o kumoko aino Hawaii. E nai mai, e palio mai, ilohi e kaleo. Hear ye, hear ye, hear ye, all persons having any business before this Honorable Supreme Court, State of Hawaii, draw nigh. Give your attention and you shall be heard. Inoho ilalo, please be seated.
Okay, please call our case.
Case number SCCQ-24-0000165. McGuire, Plaintiff Appellant versus County of Hawaiʻi et al. Defendants Appellees. Arguing for Plaintiff Appellant McGuire, Carl Osaki. Arguing for Defendants Appellees, County of Hawaiʻi et al. Brian Thomas. Argument on the merits.
All right, good evening. Aloha, everyone. The court's honored tonight to be here at the William S. Richardson School of Law, and we appreciate the school welcoming us here. Our proceeding is being broadcast live on the Judiciary's YouTube channel, as well as on Olelo. Counsel, are you both ready to proceed?
Yes, John.
All right. We've allocated 30 minutes for each side. Just to confirm, Mr. Osaki, we're going to give you a warning with 5 minutes to go so you can save some time for rebuttal. Mr. Thomas, we're going to give you a warning with 5 minutes to go on your side, part of the argument. Mr. Osaki, please proceed.
Thank you. Ladies and gentlemen, I'm honored to be here today. I represent Rebuttal McGuire, who is present in court today too. We're here to decide a certified question from the Federal District Court for the District of Hawaii. And simply put, the question is, was the elected prosecuting attorneys from the County of Hawaii the final policymakers for the County of Hawaii when it brought and maintained a prosecution against Mr. McGuire? And I believe that the answer to that question is yes. They were the final policymakers for the County of Hawaii, and they were not state actors as they argued before the Federal District Court.
Oh, let's just check. Can everyone hear just want to be sure everyone in the room.
People in the back.
Can? Okay, thumbs up. Sorry, Mr. Osaki. Just wanted to be sure everyone could hear. Thank you.
I think the controlling case in this proceeding is McMillan versus Monroe County, in which the Supreme Court stated that there are two issues when you ask about policymakers for local governmental units. The first one is whether the decision maker is the final policymaker. As in the McMillan case, in this case, that is not at issue because everyone agrees that the prosecuting attorney for the County of Hawaii was the final policymaker. So the real question then becomes, who is he the policymaker for? Is it for the County of Hawaii or is it for the state of Hawaii? Now, in McMillan, the holding was that the Alabama County sheriffs were the final policymakers in the area of law enforcement, for the state of Alabama rather than the county of Monroe. And how they got to that conclusion was to be informed by state law. So they looked at the Constitution of Alabama, which provided that sheriffs were members of the executive department and were state officials. They examined the history of why that was so, and they looked into a lynching problem that Alabama experienced in the beginning of the 20th century, and how the Alabama Constitution wanted to centralize control over state or county sheriffs who were allowing vigilantes into jails and lynching prisoners. They looked at Alabama court cases, in particular Parker versus Amaron, which explicitly held that sheriffs were executive officers of the state. And they also looked at statutes, Alabama statutes, where county commissions did not directly control or direct the sheriffs, but where the governor and the attorney general of Alabama did and could directly direct sheriffs of counties. The other controlling case that the district court dealt with was from the Ninth Circuit, Weiner versus San Diego County. And this case directly, or like this case, involved county prosecutors. Again, there was no dispute that the county prosecutor in Weiner was the final policymaker, and the question was whether he was the final policymaker for the county of San Diego or for the state of California. And the Ninth Circuit held in that case that the county prosecutor was the final policymaker for the state.
Mr. Osaki,
Yeah.
the question under McMillan was not just kind of like a general broad who's the policymaker, whether you're the sheriff or the prosecutor. It's with regards to the particular act that results in the claim under Section 1983.
Yes.
Right? And as you stated, all of these cases essentially require, in answering who the party is, who that person is acting on behalf of, must be determined by state law.
Yes.
So obviously Alabama and, McMillan, the Ninth Circuit case is dealing with California law. If you would, I think it's really important for us to really talk about the specific state law here that is at issue with regards to the prosecutors in this case, the County of Hawaii prosecutors, if you could.
Okay. And I think in doing that, it's important, as Your Honor pointed out, is to figure out exactly what the county prosecutor was doing in this case.
Right, it's as to a particular act or particular acts alleged in your complaint.
Right.
Of the complaint.
And that, I guess the cases discuss it as the area of action, and that area of action would be bringing and maintaining criminal prosecutions against citizens of the county. And in this case, it's even more particularized because the exact policy involved was the bringing and maintaining of a criminal prosecution against Mr. McGuire in this case. And that is the action that results in the 1983 violation. So that is the act that I think we have to be focused on and evaluate.
Right, but the counties, they're pointing to the control, and they say the AG still exert over the county prosecutors. But didn't Amamiya cut through that
Yes,
by saying that it's only residual authority? And even then, it's like dereliction of duty, serious dereliction of duty,
yes.
compelling interest. That's the only time. Did Amamiya resolve that issue?
I believe it did. And
How?
all right. So what Amamiya dealt with was the seeming inconsistency between the state law that requires the Attorney General to prosecute criminal violations in the state And in one of the statutes, it says unless otherwise provided by law. And then the county directive through the charters that county prosecutors prosecute violations of state law.
But on behalf of the state of Hawaii, isn't it?
No,
That's what the captions read.
it is under the authority of the Attorney General.
Right,
Right.
the captions don't read in those types of cases on behalf of the county of Hawaii, it's the state of Hawaii.
Right, and I think what McMillan and Weiner say is that mere labels do not control. You have to actually look at the function of what is being done. So when you look at the statute and charter directive to the county prosecutors, what Amemiya said is that they're not inconsistent. What they do is recognize that the Attorney General is the ultimate authority in law enforcement. But the primary responsibility belongs to the county prosecutors. And it is only in unusual and compelling circumstances that this residual power reserved to the Attorney General is triggered. So in Amemiya, it was triggered because that case involved the investigation into the Kukui Plaza project. And the allegation was that one of the targets of that investigation was the mayor.
Well, they basically thought the prosecutor should have been disqualified and recused, right? That was the
Correct.
bottom line to that case.
Correct.
Okay, so this residual authority, what is that? What's reserved for the AG so that they cannot come in and start taking cases away from the county prosecutor or interceding freely?
Well, that's what Amemiya says, right? Amemiya says that under the authority of the Attorney General does not mean and cannot mean that the Attorney General reserves some right to just usurp the power of the county prosecutor. There's got to be very good reasons to do
Compelling
so.
interest?
Yes.
Is that the standard?
Reasons, compelling reasons. And the two identified compelling reasons are either a dereliction of duty, where the county prosecutor refuses to bring a criminal prosecution. And
Well, it's not just that, they said a serious dereliction.
right, it rises to that level. Or there are circumstances where the county prosecutor just shouldn't act. And I think Amemiya shows both. And that's why the Attorney General stepped in. But the Attorney General stepped in, and unlike in other states where they can just remove the county prosecutor, that didn't happen. They went to court to get an injunction.
What about removal now? Is it only under the charter? To remove, impeach the local prosecutor, county prosecutor?
Well, the removal of the county prosecutors is defined by the charter, but it's not generated by the Attorney General.
No, but I'm saying if you want to remove the county prosecutors, does the AG still have that power? Is it retained
No,
with the AG or is it only within the confines of the charter?
only with the charter.
Thank you.
You know what, I mean, let's say in your case, the state had information that everything McGuire alleged in his federal complaint was true. The state had that. So the state actually then exercises its authority under Amemiya and comes in and intervenes in the case and dismisses McGuire's case. Would you still be arguing that the state has no control over the county prosecutor?
Well, I think what you're getting at are the circumstances where the Attorney General acts. Because I think it's,
But can't they act in any case? In other words, you know, hey, they could be on the hook and under 661B, you know, wrongful compensation. And, you know, the state pays for the county's misprosecution of individuals if they're actually innocent. So with that residual power, the state does have the authority to come in any case. In any case, they can control things. And in this example I gave to you, they actually came in and dismissed McGuire's case. And I'm wondering, how that is not exercising control over the county prosecutor.
Well, in McGuire's case, it wasn't the state, it was the county.
No, well, this is a hypothetical that I give you, it's not.
If the state came in.
Yes.
If the state came in. Okay, and I think the real question there is, why would the state come in? Why would the state come in? Because ordinarily, in the vast majority of cases, including McGuire's case, the state didn't come in.
In fact, they've never hardly come in, right? I mean, they've come in on
Because they don't know.
but they could come in. That ability to come in, doesn't that suggest control?
It suggests control, but it's control that's never used. And let's say the state attorney general got wind of the McGuire case and thought, this is not right. Okay. Would the attorney general actually come in and exercise its residual power at that point? I don't know, but you know what? I doubt it, because in the Kaneshiro case, I think the state attorney general says, look, what the county prosecutor has is the discretion on what laws to enforce, on who to prosecute, on how the prosecutions are going to be run, and how the prosecutions are going to be resolved. That's all the county prosecutors. We don't really get involved in it. And the two cases, Amemiya and Connors versus Kaneshiro, where the state did come in, the attorney general did come in, it was generated probably through the media. That's the only way the attorney general finds out, because there is no reporting from the county prosecutor to the attorney general. This is what I'm just learning.
I just want to ask one more follow-up question. You mentioned the Weiner case, and I'm just wondering, in that case, it seems somewhat similar to Hawaii. Is you have a big state actually, and the state officials going into San Diego, or could even go into smaller counties, and I guess throw their weight around. Isn't that really the same situation here?
No.
How not? Why not?
Well, in California, the Constitution actually empowers the attorney general to intercede when, in its opinion, it determines when it should step in. And
Is that a difference? Statutorily here, they're allowed to do that. And that's okay. See,
Well,
the Chief Justice has a
I-
question. That's okay.
I don't think it does.
Yeah.
Because what the statute says is that the attorney general does prosecute, but only unless otherwise provided. So you got to look at the otherwise provided, which is what the county prosecutors do. And what the county prosecutors do is prosecute.
But we kind of gave a little legs to that, or this court did in Amamiya.
Yeah.
You gave a little legs to that statute, right? To sort of elevate it and boost it a little bit to allow them to.
Yes.
Mr. Osaki, how Justice Edens referred to the statute that allows damages for somebody who's wrongfully convicted to be awarded $50,000 for each year of imprisonment. Why, if your view of this statutory framework is correct, why would it make sense to have those damages awarded against the state? Doesn't that reflect the judgment by the legislature that the state actually is fairly held accountable for what happens?
If a county prosecutor puts someone in jail wrongfully, the state answers for it, is an entirely different question from the question of the final policymaker as the county prosecutor in bringing the prosecution in the first place.
But why would it make sense to have the state held accountable? It just, isn't this reflect perhaps a judgment by the legislature that the state does have a more active role than your position suggests?
Well, I think all it does is reflect the legislative determination that the state would pay for that if a county prosecutor does it wrongfully.
But why would that make sense? Why, how would that deter misconduct if the state's picking up the bill? It's not a sensible approach. Maybe it's just a nonsensical approach. I don't know. How do you account for that?
It may be a nonsensical approach, but that's part of the way that Hawaii's statutory constitutional case law structure has it.
You know, what about the Marsman case? I think the defendants cite this, and it has some, it came after the Amamiya case. It has some fairly strong statements about the authority of the AG. So it says the prosecutor's power to investigate is derived solely from the authority of the Attorney General, and then relies on the fact that the prosecutions are brought on behalf of all of the people of Hawaii, and concluding that county prosecutors are subject to the same limits on subpoena authority that had been imposed on the AG. Again, does that suggest perhaps a view that there is more control or power vested in the AGs?
I think that case was directed more to what the actual power of the county prosecutors are, as opposed to what kind of control the AG would exercise over the county prosecutor. Because I don't believe the AG, the Attorney General, stepped in there. It's just a definition of the powers invested in the county prosecutor. And I think that's inevitable when you do have statutory law saying that the Attorney General prosecutes crimes and the county prosecutor prosecutes crimes. And there needs to be that division where Amamiya struck that balance, and that balance has worked.
Very well, thank you.
Let me ask you, the AGs in their amicus, exhaustively detail the historical roots of the AG's power and authority, and they trace it. And it's pretty powerful AG's office, historically at least. And I mean, don't those roots, that history of the Attorney General's control of prosecutions in this state suggest that they still have, that residual control to just kind of come in and usurp the authority of the county prosecutor? How do you respond to the historical context?
Right. From the historical context, I think the Attorney General does present very good reasons why there's that 1932 changes prompted by the Massey case, where the concern was martial law. So what you saw was the centralization and consolidation of power back up to the Attorney General. But that all changed in 1957 when the changes were done. And I think that the legislative history, is pretty barren on why that happened, but it happened pretty close to statehood. And since then, that regime of separation has not changed. So it's not a point where you look at the historical history, and say, well, that means the Attorney General still retains all this power. It's the development of the relationship that ended with the Amamiya balance.
Well, one thing you said earlier is kind of resonating with my mind, which is we said, hey, if the AG comes in and tries to take over a prosecution, that's a situation where they have acted. And this case is not a situation where the AGs have acted. Can you just, explain your distinction there? In other words, in your view, under Amamiya, can the AG try to act where the AG feels there are compelling public interests, which requires the AG's intervention?
I think once Amamiya comes out, the Attorney General, in looking at situations, will say and evaluate the county prosecutors and say, now, is this a situation where they're not acting and their non-action rises to the level of a serious dereliction of duty, where I gotta come in, all right? And as a practical matter, that only happens when it hits the media, when the attention and the spotlight is shining on that situation. In the run-of-the-mill cases, they don't even know about it.
I think my question is more, we're looking at McMillan's test, about looking at state law and the actual function of a government official in a particular area. Does it matter whether the situation is where the AG in this state has acted?
And the AG doesn't. The AG does not act in the vast majority of criminal prosecutions, because there's no need to.
I think the point though, is they can, the AG can, and that's the question, I guess.
They can if, right? If the county prosecutor is not acting and it's a dereliction of duty, or the county prosecutor is acting when it shouldn't, like there's a conflict of interest.
So you're still within that Amamiya
Yes,
structure.
yes. And I think that's what the amicus brief emphasized, that the Attorney General is satisfied with that arrangement. And it honors that arrangement. And I think that the petition in Connors versus Kaneshiro shows that. It shows that the Attorney General recognizes the vast discretion that the county prosecutors have.
Yeah, well, that case never ended up in an actual decision,
Right.
but the petition was brought.
And it's instructive, right? Why didn't it have a decision? Because the county prosecutor backed down.
So are you saying the only time they can and should intervene is if the prosecutor isn't discharging their duties correctly?
Yes,
Or there's a conflict of some sort?
yeah, and
Other
then-
than that, no intervention?
yes, and I think that's what Amemiya recognizes when they make that comment about the Attorney General there showing remarkable self-restraint and saying, no, we're not saying we can come in all the time, only in compelling circumstances.
That's what the court seemed to adopt.
Right. And I think that's what county prosecutors, that's what attorney generals since then have honored.
But your whole theory of your case is that such compelling circumstances actually existed here. The case never should have been brought.
No,
No?
it never should have been brought, but the county prosecutors recognize that themselves.
But wouldn't this have been a case where the AG could have intervened, in your view? That's the whole theory of your case, is it was a rotten to the core prosecution. Very get-go. So does that matter? The fact that, in fact, factually, this case fits within one of the paradigms that were identified in.
I see what your honor is saying, and I guess that would be true, but. And I guess that's how Amemiya sets it up to work, because the Attorney General wouldn't know, because the Attorney General doesn't have that control, because there's no reporting requirement from the county prosecutors to the Attorney General. So they wouldn't know about a case like this, because it is left to the county prosecutors.
Well, thank you. Anything further for the court at this point?
And I think that's why they're the final policy makers for the county.
Very well, thank you. The rest of your time. Mr. Thomas, your argument.
Good evening, Chief Justice Reclamore and Associate Justices. May it please the court, Brian Thomas, Deputy Corporation Counsel for Defendants County Hawaiʻi, Mitch Roth, Sheldon Welchin, Kate Berzik, and Sylvie Wan. Never did I think I'd be before this court this early in my career, but here I am, and it's a pleasure to be here to address an area of state law, an important area of state law, and that is whether county prosecuting attorneys act on behalf of the state and prosecuting violations of state law. An answer to this question will determine whether or not plaintiff's federal claims against the county will survive. And we do, in fact, believe this court should hold that prosecuting attorneys do act on behalf of the state. And the position on which the county relies is based on Hawaii law established in Amamiya and the statutes that Amamiya interprets. In that case is Amamiya 63, Hawaii at 424. And the principle Amamiya holds is that while county prosecuting attorneys have been delegated primary responsibility for initiating and conducting prosecutions, the Attorney General has the ultimate responsibility for enforcing penal laws of statewide application. And the county prosecuting attorneys act under the authority of the Attorney General. Now, what's interesting is that Amamiya was decided 44 years ago. And there, the Attorney General sought to disqualify and enjoin the prosecutor and its deputies from exercising their prosecutory powers. And the court did consider Hawaii law. Specifically, they considered 26-7 HRS. And that statute provides, unless otherwise provided by law, that AG, the Attorney General, shall prosecute cases involving violations of state law. Furthermore, the court also considered HRS 28-2. There, the law provides the Attorney General shall be vigilant and active in detecting offenders against the laws of the state and shall prosecute the same with diligence. Now, interpreting those statutes, Hawaii law, the court said the Attorney Generals can supersede a county prosecuting attorney in compelling circumstances.
But counsel, doesn't that limit the AG's authority to intervene? It's got to be a compelling interest, and Amamiya talks about very serious cases where the prosecutor is not discharging their public duty, serious dereliction, not acting, not prosecuting what they should. It's in those extreme cases that the AG can intervene. But other than that, it's a local election, prosecutors elected by the local voters, they're prosecuting on behalf of the county of Hawaii. Why isn't that the distinction here?
Sure, and I think to address the question, compelling circumstances, they didn't specifically identify or define compelling circumstances, but they did point out, as you mentioned, situations where prosecutors can, or attorney generals can supersede, and that is when a prosecutor refuses to act. Refusal to act, they have an obligation to prosecute cases under the authority of the Attorney General. Refusing to act, that's one of the instances where AGs can step in. And when there's a serious dereliction of duty, when public interest requires, and what can be gleaned from that is the Attorney Generals, they are able to assert control over a county prosecutor powers, because not being able to intervene when the prosecutor refuses to act, not being able to intervene when there's a serious dereliction of duty, not being able to intervene when public interest requires, that shows there's no control. That the attorney generals have no control over prosecuting powers.
But how often does that really happen in your experience, where the AGs come in and take a case away and displace the local prosecutor? How often does that really happen?
So in my short career, frankly, I'm not sure how often that has happened, but I can think of one case. I believe Justice Edens. There's a case involving the late and great Mayor Kinoy for the Big Island. He was put on trial, and the AGs stepped in that case.
Well, the AGs just investigated that case. The county didn't investigate that case. Let me ask you this. I think in touching upon what Justice Devils just sort of mentioned, this is an elected county prosecutor, and an elected county prosecutor acts on behalf of the people that elected him or her, the county people. And if you're acting on behalf of those people, you're serving those people. So the county's controlling that. And I'm just having a hard time understanding why the AGs can power grab over every county except Maui has an appointed county prosecuting attorney, but I just don't see the level of control when you're talking about the vast overwhelming numbers of prosecutions in this state being handled by the county prosecutors?
Sure, and I think, as the AG's pointed out in their amicus brief, I think in 2023, there's about 26,000 criminal cases that's been brought on behalf of the state, and maybe 3,000 or so in circuit court, and the rest were in district court. But I think it's important to look at the actual function of the prosecuting attorneys. And that's what the Omnia case, in my view, illustrates.
Well, I think their actual function is to do what the people of the county elected them to do. It's to prosecute state crimes and county ordinances. And it just seems like, you're almost transforming a plaintiff's 1983 pleading into making county prosecutors state officials. Can you address that? How, you have a 1983 action, and your position is essentially that 1983 action somehow shifts this person from a county person to a state official.
Sure. And in addressing that point, the Supreme Court in McMillan and the Wiener case did dive into that, and they talked about several factors that makes a county official policymaker for the state. And if I could, and that's why function is important, because in order for a county to be held liable for an official's conduct under 1983, a plaintiff has to establish two elements. And one, whether the official had final policymaking authority. We're not disputing that here. But two, whether the official was a policymaker for the county. And to determine whether the official was a policymaker for the county, the Supreme Court established what the courts must do. And that is identify the particular area or issue for which the official is alleged to be the policymaker, and analyze state law to discern the official's actual function. And a court's understanding, and this is from the McMillan case, a court's understanding of the actual function of a governmental official in a particular area will necessarily be dependent on the definition of an official's function under relevant state law.
Can the Big Island prosecutor come to Honolulu and start prosecuting cases and displace prosecutor on?
No, I don't think that's possible. The rules don't allow for it. I think that Honolulu, each county has their own charters that sets forth what the prosecutors are allowed to do. And that's provided to them by HRS 46-1.5 sub 17. And that's the delegated authority or the enabling legislation that the legislature has delegated to the counties, the power to prosecute crimes within their counties under the authority of the Attorney General.
Right, and under the Big Island Charter, to even be a candidate for prosecutor on the Big Island, you gotta have been a duly qualified elector for at least a year preceding the election year, right?
And that's correct.
So it's not like anyone can come in there. You gotta actually be Big Island.
Yes, and
You don't get any more county or local than that.
sure, but in the factors that the court actually in McMillan and Wiener addressed was just that. And so in McMillan, for example, or in Wiener, for example, the Ninth Circuit case, there's a set of factors that the court looked at and said the official acts for the county. And that was, district attorneys are listed as county officers. We have that here. County sets their salaries, that applies here. The district attorneys must be registered to vote in the county, and as you pointed out, we have that here. And four, the county supervises their conduct and use of public funds. I think that applies here. And the fifth factor that the court looked at in favor of upholding the prosecutor on behalf of the county was that district attorneys can be removed from office under the same procedures as other county officers.
Yeah, but all those factors, even with all those factors, the court held that they were acting as state officials. And one key distinction from our case is the statutes of California provide the Attorney General has direct supervision over the district attorneys of the several counties and may require of them written reports as to the condition of public business entrusted in their charge, which I think Mr. Osaki referred to. So why doesn't that, Why doesn't that in this case, or why doesn't the fact that we have even less stringent controls in Hawaii suggest that we would be dealing with county officers here?
Sure, I believe that's the third factor that the court found in favor of the state. And I think there are some parallels here. Because Amamiya, in our view, allows the county prosecutor, the attorney general, to come in and assume powers of the prosecuting attorney when there is a serious dereliction of duty, or when they refuse to act, when public interest requires. And so I believe, Amamiya alone kind of parallels that factor 3 that you just talked about. Because in the Wiener case, the court did mention that attorney generals in California can assume all powers of district attorney when it's their opinion that state law is not adequately enforced. And that's just like the Amamiya holding out to this court.
It seems like a little bit of a lower standard than what Amamiya said, but let me ask you this. What about the county chiefs of police and police officers? Are they investigating on behalf of the state?
So I guess the chief of police, they are hired by the police commission, but are you talking in terms of?
I'm saying you would not be arguing that like the chief of police is acting on behalf of the state because he's investigating state laws?
I think there's a difference there, just because unlike prosecuting attorneys who are elected officials, the chief of police, there's a county police commission, and they're the ones who hire the chiefs.
But historically, the attorney general could remove county prosecutors, right? Or had some supervision over county prosecutors. And that has totally changed. As Justice Devins has pointed out, you have to be a resident to even run for county prosecutor. The county prosecutors, except for Maui, are elected only by the people of the county. When you look at how they're removed under 9.6 of the charter, they are removed either by recall or impeachment, and it's only by the people of that county. So they're not really under the jurisdiction of the attorney general, are they?
Well, I mean, that's factors that the McMillan court actually analyzed. That's, the district attorneys in the California courts, they're elected by the officials. Here, that's the same. And the court still found, regardless of that, they still found that prosecuting attorneys act on behalf of the state in prosecutions. And I'm not saying for every duty or administrative task that the county prosecuting attorneys are for the state. I think it's just.
But you agree it's a matter of state law, and it appears that California's provisions there are some provisions within their constitution. We don't have anything in our constitution that says that the attorney general supervises everything, do we?
No, and I don't think so. Well, no, not to my knowledge. But here, in this case, I think it's important to remember that the statutes all point to that the prosecuting attorneys garner their power from the attorney general. And that's apparent in the county charters, all of them.
Right, but the statute evolved over time, right? It used to be under the control and direction. Those were the two words that were used, and it's now under the authority. That's a big difference, wouldn't you agree? Control and direction versus acting under the authority.
I think there's a difference there too. Yes, I would agree. But again, going back to Amamiya, the Amamiya case, they allowed their attorney general to step in with his dereliction of duty.
But they say it's a very narrow, it's restrained. That's the word the court used. Restrained authority, narrow. And now you need compelling interests.
And so you take those factors out. Then who's going to monitor? There has to be some checks and balances here.
Well, the check is if you go off the rails, they're going to jump in.
Right, and that is the
corruption, dereliction of duty.
Exactly, and that's what we're arguing here.
That'd be compelling.
Yes, and that's what we're arguing here. Attorney general, they can assume all powers of the prosecuting attorney when those circumstances occur. And because of that, I mean, there is a level of control there, because they can assume.
So the mere ability to control is sufficient. That's all you have, it seems. The mere ability to control is sufficient, is a sufficient degree of control.
I would agree. It is, as well as the fact that all suits in the state of Hawaii are brought on behalf of the state. I mean, not the counties. And that's one of the factors that the California courts looked at, is that all suits, were brought on behalf of the state of California. And then that's exactly what we have here.
Mr. Osaki would just say that's a kind of a labeling thing. That's not really looking at the state law, which starts, of course, with the Constitution. Recognizing that the AG is clearly under our Constitution, the chief legal officer of the state. But, one of the things in Amamiya that this court said that was so important is that what that means is that, what it doesn't mean is that at the sole discretion of the AG, they can just kind of go in there and take a case away. If you think about it, in Amamiya, they went to the courts, right? The court is the one that found that the county prosecutor was disqualified there. In the Connors versus Kaneshiro, again, the attorney general came to this court to bring a petition to seek to have the county prosecutor relieved of his duties. So it's not like an AG under Amamiya would just have the authority to just step in at any time, perhaps.
That's correct, and that's what the Amamiya court did hold. The AGs can't step in at its sole discretion to usurp the power.
But isn't that sort of a distinction from those, certainly from Wiener and the other cases where the AGs had more of a supervisory statutory authority to do things on its own.
That's correct, and I think I would submit. I mean that's the difference here. The attorney generals they don't have direct supervision, of district attorneys, and it would be hard. It would be hard to supervise 26,000 cases in any given year. And I think that's the leeway and the room that the court Amamiya provided to the attorney generals.
I mean, it's really interesting because certainly under the statutory authority, first of all, the prosecutor authority is derived because the counties were given under the Constitution the right to create its charter, and the charters, as you pointed to, are created under statutory authority. And there is some reference to prosecutors having authority under the AG. So that's the language that you folks keep pointing to. But that's just one of a number of sort of factors and elements that we need to consider. That cannot be the end all to this analysis.
Correct. And first, there's 2 points to that. And first, as Chief Justice mentioned during opening argument was the Marsden case. And in the Marsden case, that was decided 7 years after Amamiya. And the court there, it said, quote, that the prosecutor conducts prosecutions for offenses against the laws of the state pursuant to the county charter. It does so on behalf of all the people of the state of Hawaii. So not just the counties. I mean, it's the entire state of Hawaii. But also when considering the factors that the Wiener court found in favor that the officials were acting on behalf of the state. One, we already discussed all suits are brought in the name of California. The second factor was county authority to review a district attorney's conduct specifically excludes interference with their investigative and prosecutory functions. So in here in Hawaii, I mean, there's nothing that says that anyone can interfere with the prosecuting attorney's functions. And so I think that again parallels to the California case. And 3, we already discussed AGs have direct supervision over DAs, can require written reports, and can take full charge of any investigation or prosecution. And that latter
Counsel, I'm sorry to interrupt you, but how do we get, Amamiya is still good law in your mind?
Yes.
So how do we get around the language of the case where it says, only in certain compelling circumstances is the AG empowered to intercede? And the court at that time said, we agree with that proposition. How do we get around that where it's limited now to certain circumstances, and examples the court gave at the time were very extreme examples, Ms. Conlon.
Sure, and I think just
It's
looking at,
not coming in at any old time.
right, and just, I think taking a step back and understanding what the actual function and the particular issue that prosecuting attorneys are required to do and fulfill. And that's the key part to determining whether or not county prosecuting attorneys are policymakers for the state, is the function they serve. And all the statutes point that they prosecute cases under the authority of Attorney General. That's the function they serve.
Don't they seem to be operating pretty autonomously?
I would
They're in
agree.
the county, they're on behalf of the county, they're elected by county residents. I mean,
I would agree, and I think, there is a distinction without difference there. I mean, they both do the same jobs, and I think, okay, so what happens if the AG step in? Nothing happens, the case still proceeds, the defendants are subject to prosecution, just as if the county prosecutor was there, and that's the function that the courts in the Supreme Court in McMillan and the Ninth Circuit in Wiener really discussed and emphasized, and that's why they found in favor that the county prosecuting attorney were acting on behalf of the state. And, the Wiener case, they cite to Pitt's case, Pitts v. County of Kern. Again, it's a California case, and I'll just dive right in here. And, the court in Pitts concluded that when preparing to prosecute and when prosecuting criminal violations of state law, a district attorney represents the state and is not a policymaker for the county. While this issue depends on analysis of state law, and hence the conclusions of other jurisdictions are not conclusive, we note other jurisdictions have reached the same result. I just want to go through the other jurisdictions. And so, for example, in Ohio, a city prosecutor acts as a state agent when prosecuting straight criminal charges. In Oklahoma,
what about the Orso case though? There was a determination by the court that the county prosecutor was a county official.
I'm sorry, which case?
Orso.
Sorry, Your Honor, I'm not familiar with that case.
Yeah, the U.S. District Court did cite it in the certified question. I wanted to switch gears a little bit because you mentioned in your briefing, you make this comment. Deeming county prosecutors as county officials in criminal prosecutions would likely increase Section 1983 cases against Hawaii's counties for which the sovereign immunity and absolute and qualified immunities defense would be available. Now, the qualified immunity text, it's nowhere in the federal constitution, right? And it's nowhere in Section 1983, which is an 1871 law, right? And you know what that law is really called? What was it called?
Sorry,
What was the Section 1983?
It's a Monell claim.
The Ku Klux Klan Act from 1871 in Reconstruction. That's the Section 1983 Act. So we don't have qualified immunity in the text of the Constitution. And I would actually invite the originalists to try to find a historic understanding of prosecutorial power with respect to immunity anywhere. In 1967, the United States Supreme Court made up this idea about qualified immunity. And I think we're seeing now that immunity to prosecutors is somewhat chilling, given today's Department of Justice. And I'm just wondering why Hawaii should effectively extend SCOTUS's judicially created immunity to protect bad acting prosecutors in the state.
Thank you for the question, Justice Evans. And so I guess the legal precept of sovereign immunity is to protect the sovereign. Without immunity, it would disrupt the functions of government, because then you're inviting everyone to sue government officials all the time. And I think extending immunity, just like how the Supreme Court did in McMillan and in Wiener, but by finding that county prosecutors were acting on behalf of the state, I think that's a seamless transition here. And going back to the other cases that did extend immunity. So in Mississippi, for example, the district attorney is a state official when allegedly violating court orders and failing to report, investigate, and effectively prosecute sexual abuse allegations. Hence, damages claim barred by the 11th Amendment. And again, in Colorado, District Attorney's Office entitled to 11th Amendment immunity. That's what the Colorado courts have decided. And these cases, again, are all cited in Pitts v. County of Kern. And
Well,
so,
this onslaught of lawsuits you think could erupt. I mean, what about the purpose of the 1871 Act, which was really to protect the constitutional and civil rights of individuals where local municipalities were harming them? That was the purpose of them. And it just seems that if we were to subscribe to your theories here, that we would essentially be not satisfying the purpose of the 1871 Act. And I understand your comments about immunity. And I'll just leave it at that. But thank you, Mr. Tom.
thank you. And I guess to follow up, I mean, yes, prosecutors do have prosecutorial immunity, but that immunity is for acts that are tied to the criminal or to the investigation or acts tied to the judicial phase of the criminal process. You know, prosecutors aren't immune for administrative tasks or other investigative tasks. Likewise, sovereign immunity. I mean, I think the state's immune unless they consent to be sued. And I think in Hawaii, there's you know, they have consented to sue in certain torts. There are exceptions, but again, you know, there has to be some level of immunity to protect the function of government.
You would still have qualified immunity, but what you're requesting here is absolute immunity to be able to prosecute with impunity without any check or balance, whatever, under 42 USC 1983. Obviously, you could still be subject to a malicious prosecution lawsuit, but you're asking for absolute immunity here, that a prosecutor should not be subjected to any questions under 42 USC 1983 for having brought a malicious lawsuit. That's basically what you're asking for.
Yes, and just in line with the Supreme Court case in McMillan and the Ninth Circuit's holding in Wiener. But also, you know, I think there is a concern, you know, okay, so if we're gonna have blanket immunity against the county for prosecutors' conduct, you know, what kind of recourse or relief do plaintiffs have? I think they still do have relief, but by suing the prosecutors in their individual capacity and in an official capacity. And you know, if they can.
We're obviously just dealing with the official capacity here today, because clearly there is no immunity for the prosecutors' alleged actions in their individual capacity, since the allegation is that they were bringing these suits for their own personal electoral gain, right?
Right. I don't want to dive too far into the merits, but I will say that a lot of the acts alleged in the complaint, the investigative acts were by the prosecutors were done. Sorry, let me rephrase. The acts that are alleged the prosecutors did was done after the investigation had already been completed. So I think the complaint talks about the police officers conducted their interviews, you know, they went to the crime scene, did a scene check. All that happened before the county prosecutors got their hands on the case. And so, without diving too far deep into the context of the allegations here, I mean, I think, again, I think there is a way for plaintiffs such as here to seek relief.
What we're dealing with here is the issue of whether or not the county can be held liable under 42 USC, municipal liability, right? That's really what we're dealing with here, because clearly the plaintiff can continue to pursue the prosecutors in their individual capacities. Then the issue becomes who's going to pay for that if they're found liable.
Sure, and again, you know, I would submit that the county here was acting on behalf of the state in the prosecutions, and just like the courts held in McMillan and Wiener, this court should likewise find that prosecuting attorneys act on behalf of the state when prosecuting violations of state law. And I'll end with this. I think this court recently in State v. Hernane, there's a footnote there. And this court recognized as agents of the state of Hawaii, county prosecutors are obligated to fulfill the responsibilities of the state of Hawaii in the prosecutions. And truly, that's the function that county prosecutors serve, for the people of the state of Hawaii. And if we look at the function as the tests, as the framework has established, that's what we have to focus on. And
Very well, anything further for the court?
no, Your Honor.
Thank you very
Thank
much, Mr. Thomas. We'll hear from Mr. Osaki. Osaki, can I ask you to respond to the very last argument made by the defendants related to this, the Hernane case, which does say county prosecutors are agents of the state of Hawaii required to fulfill the responsibilities of the state of Hawaii in their prosecutions. Does that not suggest a level of control or involvement with the state beyond what you're suggesting?
No, I think the issue or the statement, that footnote, really doesn't pertain to the question of control by the Attorney General over the county prosecutors and when that happens.
That statement was not necessary to the holding of the case.
Yeah. Sure.
Which was whether a defendant that's held in state custody in a mainland prison after his conviction and is set aside in the order of a new trial is not, whether it's excludable under Rule 48 for speedy trial purposes. That was the issue of the case, which really had nothing to do with county prosecutors' authority or duty.
Right.
But didn't the prosecutor there say it's not our fault? The defendant wasn't brought back by the Department of Public Safety. That's not our fault, not on us. And we said, no, it actually is on you because you're an agent of the state of Hawaii. Is that relevant here or not relevant?
No, it's not relevant because if you look at what the prosecutors are doing in that case, the functions that they were exercising was in that transport of that prisoner and arranging with other agencies to get the prisoner back. It wasn't the function of bringing and maintaining prosecution, which is what we're talking about here. And I think what I hear from the county is an effort to line up states like California and Alabama. I think they put Ohio in that bucket. But there's no analysis of the state law in those particular states to explain why that holding happened. And in this case, when you look at the history of Hawaii law and what the Constitution and how the Constitution divides power, we have home rule. The Constitution says the counties create their own charters that doesn't have to come before the state legislature for approval. They do it themselves.
That's an interesting point you missed, Mr. Osaki, about the home rule, because it strikes me that you have a county court counsel who usually, I would think, would be pressing for autonomy and self-rule. And I mean, does it seem to you that there's sort of the shift is, well, we usually go home rule and everything's self-rule and autonomy, but that kind of hurts us in this litigation, so we're going to take a different tack?
Well, yeah, I mean, they're scurrying for a reason to avoid potential liability. And that's all it is. And what that makes their argument is the possibility that the Attorney General might step in to a situation, which never happened. Never happened. And we're talking about one policy decision, which was to bring the prosecution against Mr. McGuire and maintain it. That's what we're talking here. And that was made by the final policymaker of the county.
Anything further for the court at this time? Wrap up.
I think he did make one comment about that Pitts versus Kern case, where the California Supreme Court said that the district attorney was acting on behalf of the state. And it's interesting what the Weiner court said about that. The Weiner court said,
Is it Weiner or Wiener?
that's
I mean, either way, it's an unfortunate name both ways.
I had to look up how to pronounce a meeting. But what Weiner or Wiener said was that we're going to make our own decision because ultimately that's a federal question under 1983. That's informed by the state law. So I think when your honors look at what the state law is here, what the structure is, and how this very court apportioned that power, the conclusion cannot be anything but the county prosecutor acts on behalf of the county in bringing criminal prosecutions, and in particular, this one.
Very well. Thank you, Mr. Osaki. Thank you, Mr. Thomas. The court will take this matter under advisement. I want to thank both Mr. Osaki and Mr. Thomas for participating in our argument tonight. Can you please all join me in acknowledging? On behalf of the court, I want to thank the students, faculty, and administrators of the law school for welcoming us here tonight. It's always a privilege to be here. Something we've done every year now for quite some time, and we especially cherish the opportunity to be here at 5 o'clock. So those students who are evening part-time students are able to be here, and we really enjoy that, and are grateful to Professor Skilling and Carrie Carolyn for sort of organizing that aspect of this program and making events like this accessible to all students at the law school. Want to thank Professor Serrano and Sprout from Kahuliao for this beautiful day of welcome and aloha. Very much appreciate that. We have a great relationship between the law school and the judiciary that obviously goes back to the very founding of the school, back to Chief Justice Richardson, and the deep ties that exist. And you can see those in so many different ways, such as coming here for argument, collaborating on access to justice, collaborating on our efforts to take the Supreme Court out in the community, among others. And especially, we have deep ties in terms of folks who are at the courts now, or Richardson graduates, 3 of whom now sit on this court, a majority of the court. And we have many alumni of the school serving as judges and law clerks and externs. I think about half the people here are current or former externs for us, so that's awesome. And I really want to thank everyone who made this event possible. Dean Camille Nelson, who's always very gracious in welcoming us. Associate Dean Tricia Nakamura, Tracy Sir, and Suman Gill, Stephen Park, and Kevin Nguyen, all of whom worked very hard. I just really got a shout out to Tracy and Dean Nakamura for their super hard work. They really do. I think they cover about 3 different jobs making things happen, and we're very thankful to them and Anne for all their hard work. So please join me in acknowledging them. All right. Well, also we want to thank all those folks from the court who helped us set up here and made all this happen. Thank you to Kurt Shibata, our bailiff, for doing all the tech side of getting this argument out into the community and around the world. And we really look forward to meeting with the students after having a short break. So we'll take a short break and be back again. And again, for those of you who are going to be leaving, thank you so much and aloha.
Oh, you know now, these right? Well, my name here, Hawaii. Honorable Supreme Court of the State of Hawaii is now adjourned.
Please be seated.